believe in COVID theater, and you do see lingering elements of that, although even some of the most restrictive states are starting to repeal vaccine passports and some of these mandates. You still have this federal rule that was just extended forcing people to wear masks on airplanes. And it's not something that's grounded in any science, because if you have somebody sitting in the window seat and they're nibbling on peanuts for 2.5 hours, they can have their mask down. You have the person in the middle seat that is not eating. If they just wanted to read a magazine without the mask, then somehow that would be a big problem. And it's turned the airlines into having to police this. It's created a lot of unruly passenger situations because it's so frustrating for people. And so this is something that I've been opposed to for a long time. You know, unfortunately, there's not really been successful legal challenges to this. And I think most people thought that this was going to go to the way of the buffalo, but you have an extension. Then you have Fauci coming out saying they may need to impose additional restrictions in the future. And we need to let people live their life. Obviously, in Florida, what we have control over, we do that. But in this federal mandate for air travel, I think as good as we've done on domestic tourism, and we're the #1 state people seem to want to come to, I think more people would want to fly if they did not have to have that for 2 hours or 2.5 hours. And so I'm going to let Attorney General Moody come up, and then I'll make my second announcement. But she's leading the effort to bring a legal challenge to this, because I think it's important in and of itself, but there's also an important legal principle at stake. So I support her efforts in this. It's amazing that this has gone on as long as it has, and I'm going to let her come up and talk about it.
Thank you. Go ahead. Well, good morning, and thank you for being here for this important announcement. This morning, the state of Florida, joined by 20 other states, has filed an action against the Biden administration and multiple parties within to challenge the mandatory mask mandate within transportation hubs and on airplanes. This order is completely outside the bounds of the scope of federal power, as we have argued successfully in numerous other cases. The CDC and the federal government and the Biden administration never had the power to issue this order originally, and now we are seeing that almost 75% of these unruly, sometimes violent incidents are based on this unlawful mask mandate. And I know that if you travel at all, everywhere you go, people are frustrated and taking it out on the employees that are charged with enforcing this rule, that they have to wear a mask when it is an unfounded rule and order. And many people don't realize that this unlawful order carries with it not just civil penalties, but criminal penalties. Although in the same order in which they mandated folks unfounded or unnecessarily wear masks throughout the United States in transportation hubs, and by the way, that includes taxis and Ubers and ferries and all of these other transportation methods, not just planes, they also included with it a criminal penalty. So you can imagine if you are a flight attendant or someone who works within an airport or on a ferry or an Uber driver, you are now charged with enforcing this unreasonable requirement. And what is not surprising is that within the same mandate that's unlawful, they say, we're going to issue a civil and criminal penalties, but don't worry, we probably won't even enforce the criminal penalties, which is MO for this administration throughout the nation, which causes so much chaos and confusion when they don't even enforce their own laws. This must be lifted. We have a lot of faith in the court that they will agree with our legal analysis. I think the governor would agree that we would hope and still demand that this administration take their tough on travel stance to the border. But it seems that the protection of the American people takes a back seat to this radical scheme. And so this is meant to push back on, yet again, another unlawful power grab by the Biden administration. The governor and I are so proud to lead states across this nation, 21 in total, to ensure that this administration simply stays within their scope of power and follows the law. Thank you so much.
And we've, so you remember, we won against the CDC in the Middle District of Florida with how they handled the cruise ships. They would have never moved if we had not brought that suit, and so Attorney General deserves a lot of credit for that. We had a judge rule for Norwegian on a bizarre analysis of law saying First Amendment grounds meant we couldn't bar vaccine passports. That's on appeal. I can't imagine that that would stick as law. That was a really bizarre ruling. But we were able to win on the big cruise ship case. We were also able to win on the OSHA mandate case, and then because we've provided substantive protections for Florida employees, we've been able to save the jobs against a lot of other vax mandates. So we're very much proud of that. And we're also getting traction in this immigration case, that we're doing against catch and release and some of Biden's policies. And so I think the state has done some effective litigating on behalf of Floridians to push back against an overreach from the Biden administration. I think Attorney General's done a great job of leading the way on that regard. I'm also here to announce that prior to coming into this press conference, I officially vetoed the congressional redistricting map, as I said that I would. And so we have a veto message that has attached this stellar memo by our general counsel, Ryan Newman, who lays out what he has been saying from the very beginning as to why the approach that the legislature took was defective. In their, I guess, understandable zeal to try to comply with what they believe the Florida Constitution was required, they forgot to make sure what they were doing complied with the 14th Amendment of the U.S. Constitution. And so I think that this is a very, very cogent analysis of what we see as the problems. Later this afternoon, I will be issuing a proclamation to do a special legislative session. That is going to be in the middle of April. We're working on the precise dates with the legislative leaders, but I would count on sometime after Easter. We will be able to come back in and be able to get this across the finish line. So I want to thank our GC for doing this, and that veto is official. And with that, we're happy to take questions about any of these.
In the legislative call for the special session in mid-April, will data privacy?
So here's what I would say. I would love to have property insurance. I'd love to have data privacy. I would love to have constitutional carry. There's a lot of great things. But, we just went through a legislative session where they failed to deliver on some of those priorities. And so what I will do is I will ask the legislative leaders, is there something that you can get across the finish line? And I will encourage them to do that because I think that there's a lot of key things that we could do. So that is a possibility. The initial call will just be for the congressional maps, but it is absolutely possible that when they actually convene for the special session, that you could see additional issues raised in it.
Do you think that where the legislature left the property insurance reform bill from this session unfinished, do you think that there's room for common ground for a special session, or do you think that issue has to be handled next year?
It won't go all the way to next year. I think at the latest it will be when Speaker Renner takes over. I think right after the election they will punch it through. I think so. That's the latest it will go. I'd like to do it before then because I think it will help try to realign incentives in the market. Everything is going up. There's a general inflation that's affecting everything. But as you heard Altmaier talk about how Florida had 8% of the claims nationwide and over 75% of the litigation, clearly, there's some dysfunction in this. SB 76 did do some good things, but that was a compromise, and I don't think it did quite enough. We have had a couple carriers come in, which is great, but I think if we did more, we'd be able to do it. Now, the Senate was working on it. We were very supportive of that, but basically that ran into a brick wall in the House. And so if the House is willing to entertain it, then they should absolutely do it. I am pretty confident, though, in my conversations with both Senator Pasadomo and Speaker-designate Renner, that this will absolutely become a reality, and it will not wait until the actual session in 2023. It will be done this year.
How displeased were you with the FDLE commissioner's performance, and did it involve immigration enforcement?
No, I think he's faithfully served the state for decades, and we really much appreciate it. He's been in that position for for over 4 or 5 years. I mean, so that's a long run. And I think now we're in a situation where we have an opportunity to focus on some other issues. But, you know, I think it was just kind of a natural course of thing, and I think he served the state well, and I wish him well.
Redistricting, I assume you have spoken with legislative leaders, and they're willing to come back in special session?
Yes, they are. Yep, yes.
So you are not expecting this to directly go to the courts?
No, exactly. So, yeah, so as I think you know, many of you know, there have been, both in state court and federal court, there have been malapportionment cases that have been filed, and that's basically if you don't have a congressional map, our state gained population, we clearly need 28 districts, and so people would potentially have a claim there. Those courts were starting to move on that. I thought it was premature, given that this hadn't even been presented to me, but clearly now with the veto, and then later today with the announcement of a special session, I would imagine that those proceedings would be stayed, because clearly this is the legislature, and then in this case the governor's prerogative, since I have to put my signature on it, to be able to do this. So that you're not going to have it drawn by a court. I think we all agree that we have to work through this, and we understand kind of if the legislator's map, let's say the Senate's map had gone in, that would have been challenged on some of the grounds that we've articulated in this memo. If they go in a direction that we were advocating, it will be challenged on the other side. We understand that, and so that will happen. But it is absolutely, I think, the responsibility of the legislature to produce a map that can actually be signed into law.
So, forgive me for only just being able to scan it very quickly, sir. I do like to read things before I ask you questions, but I would like to ask you about, it looks like you're talking about non-diminishment and how you feel that maybe the non-diminishment standard that they've used is violative of the U.S. Constitution and federal law. So, but in how you want them to approach it, are you taking the position that you think that ultimately there needs to be litigation that would maybe knock out just that portion, or do you think all of fair districts needs to go and should be tossed aside?
Well, look, I think our goal in this was just to have a constitutional map. We were not trying to necessarily plot any type of litigation strategy. I think if you did a map along the lines that we had proposed, that will be challenged, and there'll be plaintiffs that will say that big district in North Florida, the District 5, that's diminishment, and that must be put in. And they're going to ask courts, most likely state courts up to the Florida Supreme Court, to put that district back in, and they will cite that provision of the Florida Constitution. We will obviously say it's unconstitutional to draw a district like that where race is the only factor. And so that will be a decision. That probably is enough to resolve the map. However, if it got to the point where you said that this is what the Florida Constitution requires 100%, and the non-diminishment has not been fully vetted or fleshed out because we've only had one redistricting cycle. We basically said non-diminishment means you can't diminish a VRA-protected majority-minority district like that. That's the maximum it could be and satisfy the federal Constitution. If they believe that, well, then obviously this would not be implicated and they could uphold the map. If they didn't believe it, if they did the legislators' analysis where even a 30% couldn't be diminished, well, then I think then you run into where the redistricting amendments become problematic. And I do think, just as a constitutional matter, the diminishment only applied under Section 5. It doesn't even apply anymore, but at the time, it only applied under covered jurisdictions. There was pervasive evidence in the middle part of the 20th century of basically not allowing very many people to vote based on race. And so you had very tough medicine, but there was a showing as to why using race in that regard was something that was appropriate. The redistricting amendments in Florida just said the entire state with no showing that it would be appropriate to use race in that fashion. I think that raises huge constitutional concerns. I also think there's an internal inconsistency in Florida's redistricting amendments in the Tier 1. Because on the one hand, it says you can't use criteria that would favor an incumbent or a political party. But on the other hand, you say that you have to allow under Section 2 minority candidate to elect a candidate the choice. The problem is when they do that functional analysis, what is the functional analysis leading to? It is leading to a partisan analysis because the analysis is, can the district elect an African-American Democrat? So you have to consider partisanship to be able to satisfy that. So I think that there's an internal inconsistency there. So to sum up, Does it mean that the fair districts will necessarily have to be challenged? No, because they can interpret that non-diminishment provision in saying it doesn't apply short of a majority-minority district, and then I don't think it would raise that. If they say non-diminishment applies to any district based on whatever, even 30%, 35%, then I think that puts that in peril in terms of how that would do under the 14th Amendment. I don't know. I mean, it just depends. You know, this is a big budget, as you guys know. I'm going through all the bills. I've gone through a number of them, but I got a lot more legislation to go through. We're going through, I haven't even had a full budget briefing. You know, we do this over a long period of time. We go over the different projects. So I just don't know when that's going to be done. My sense would be, you know, it's going to take us several weeks to go through the budget situation. So I would not anticipate it being done by then per se, but it's not really related to that. It's just a matter of it takes time to go through and vet these things. I mean, I think most of you know the House came in with a budget. So my budget was $99.7 billion, but in fairness to the legislature, they increased the Medicaid by hundreds of millions of dollars. They increased the work program by a lot. So just constant, it would have been over $100 billion even with my budget. So the House did $105 billion, the Senate did $108 billion. They go to conference and they come out with $112 billion. I don't know how that works, but that's just the reality. So it just means we're going to have to scrutinize this. I mean, I think if you look at what's going on with our receipts, I think we had, $450 million above estimate for February. So they literally are doing this estimate in January. For February, we're already almost $500 million over. I think March is going to be very strong. I haven't gotten those updates yet. So we're going to have more surplus general revenue than we even forecasted. And this is one of the biggest surplus. At the same time, you know, I want to protect that because we don't know what's going to happen. If you watched the cabinet meeting, they had Ben Watkins talk about interest rates are going up. You know, that could potentially be a drag on the economy. You know, you could end up with Biden before he's out of office with some type of a recession. So I want to make sure we have a cushion to be able to deal with that. So it just requires us to go through a lot. I think sometimes it's actually easier for the legislature to do the budget when it's a little tighter, because I think what they're able to say is, look, you know, we're just can't afford it. This year, they couldn't tell anybody that their projects couldn't be afforded, because honestly, we could afford it if we wanted to. It's just a matter about how much money, you know, do you want to make sure that we're building for future events and future surpluses. Also, just want to say one thing in relation to one of the things I saw yesterday. You know, we signed the Parents' Rights in Education bill. It's interesting when, like, a Disney-owned ABC would put that out on tweet. They'd say, Governor DeSantis signs bill to prohibit instruction in sexual identity and gender identity in some grades. Some grades. Why would they say some grades instead of K through 3? It's just amazing if you're trying to inform the... So you saw a lot of this, but then for Disney to come out and put a statement and say that the bill should have never passed and that they are going to actively work to repeal it, I think, one, was fundamentally dishonest, but two, I think that crossed the line. This state is governed by the interests of the people of the state of Florida. It is not based on the demands of California corporate executives. They do not run this state. They do not control this state. I also thought it was interesting. I talked to the Speaker of the House yesterday afternoon, and he said Disney never called them while they were putting this through the House. They didn't seem to have a problem with it when it was going through. If this was such an affront, why weren't they speaking up at the outset? And yet they won't. And then for them to say they're going to actively work to repeal substantive protections for parents as a company that is supposedly marketing its services to parents with young children, I think they crossed the line. And, you know, people ask me, you know, kind of about, you know, their posture on the bill. I said, you know what? If we would have put in the bill that you were not allowed to have curriculum that discussed the oppression of the Uyghurs in China, Disney would have endorsed that in a second. And that's the hypocrisy of this. And, you know, we're going to make sure we're fighting back when people are threatening our parents and threatening our kids. What's that?
Is the legislature going to agree with your interpretation?
So here's what I think. I think they agree on this. I think what they said is initially, We just have to follow the case law from last decade, which I'm not sure, quite frankly, is going to end up being good law if this goes up to the current court. And we're going to follow the text of the state constitution. And they really didn't do the analysis about the 14th Amendment. And I think their view is, well, it's in our state constitution. Of course, that's a compelling state interest. That has not ever been held to be the case, and that's not. So I think now they do understand that this is something that is a very, very live issue. I mean, you can just see the U.S. Supreme Court just kicked back the Wisconsin legislative districts. Why? Because there was racial gerrymandering. The Supreme Court took the Alabama case. They put a stay on the decision of the 3-judge panel. They took the Alabama case. They would not have taken that case under that posture unless they were going to make sure that they're going to limit the role that race plays in congressional redistricting. I think that's almost assuredly. So I think that they understand kind of some of the judicial evolutions that have happened over the last few months. And quite frankly, I mean, I think this analysis is something that's been very powerful. I think most people, certainly most conservative lawyers who look at these issues, agree with this analysis. And obviously, the leadership in the legislature, they're going to be more in line with what a lot of the conservative lawyers think. So I think we understand, but we also understand that what they did in the map that I just vetoed, they did a primary and secondary map. I understood what the Senate did to keep that long snake district, which was a pure racial gerrymander. It was not a VRA protected seat. But I understand that because they basically said, look, the state constitution says you cannot diminish. If we don't draw it like that and weave in and out of communities to focus on, maximizing the number of people by race, then we will diminish. And so they were reading that very literally. They followed kind of what the court had said last decade. So I totally understand that. I have no clue how the House then did a massive diminishment, but then still did a race-based district where they were trying to get it perform in a certain way. That I just don't understand. So I understand what the Senate did. I think that runs afoul of the 14th Amendment. I don't understand the primary map that I vetoed, how they could have ended up in that situation. So we're going to work through these issues. I think at the end of the day, there's a lot that was going on in session. And then now they'll be able to come back and really focus on this. There may be some other issues to deal with, and hopefully there are. But certainly, I think they're going to have an ability to do this and do this well.
Procedurally on this
About the
special.
lawsuit, the governor said, I'm sorry, there's folks, former FDA chiefs and other folks are saying that the mask mandate for airplanes and whatnot is not going to last until the end of the month, that Biden's just trying to figure everything out. Why is this lawsuit necessary if we're going to...
Well, I'll let Ashley come in and speak to that. But I mean, look, they said 15 days to slow the spread. Okay, so at the end of the day, there's a legal principle at stake here. There's a constitutional principle at stake here. And you had Fauci. He had been basically on hiatus for a while, and now he's reemerged saying, you can't rule out more restrictions at some point in the future, even though these restrictions have been ineffective. So even if they let it lapse, I definitely think as we get into next fall and winter, there could be an attempt to reimpose it. But I'll let Ashley speak to that.
Sure, and this is a common misunderstanding. The original CDC order, which was unlawful from the beginning, it totally goes outside the scope of federal power. It gave no one notice and comment. It imposes some sanctions, but the TSA has a separate penalty structure. And so even though you have the original order, you have this TSA order that imposes a penalty structure, and that's what they keep re-upping and keep extending. But the original order is still in place. It still also has a penalty to it. And so regardless of whether they extend this TSA order again, which, Biden has routinely said, I know I don't have authority to do something, and then does it anyway. I don't know why, even when it makes no sense. I don't think anyone should assume that they're not going to extend it again in April, because that has been the history of this administration. But even if they didn't, we would still have the underlying unlawful CDC order.
Have either of you flown lately?
I fly commercial aircraft, yes.
Well, because
You ever been in the middle seat on a commercial aircraft?
State. I mean, I've obviously done that a lot in my life, and I can tell you that it's not necessarily always the most pleasant experience when you're dealing with commercial air travel. But to impose that, and look, it's less about. I think less about me. Like if I'm traveling with my family, like my kids, 5, 4, and 2, I don't even know what it would be like to try to do, because we've never put a mask on them. But I know a lot of these families and these kids, you know, every time as a parent you would bring kids on an airplane, you always don't know, like, how are they going to react? How are they going to behave? And to have that thrown into the mix, I know has been very frustrating for an awful lot of parents.
And I can tell you routinely in my travels, watching mothers, exasperated fathers trying to control their young children, it has caused so much confusion, so much chaos, so much pressure on the employees. And as you know, the airlines themselves have demanded that the administration take a look at that and consider what they're forcing on them to do. Passengers become frustrated. I can't tell you how many times I've seen people get frustrated and angry and speak out against these flight attendants that are just trying to keep a serene, safe environment. So for many reasons, this is the right time to rescind this order.
All right, thanks, guys.
A bit about your communication with Justice Thomas regarding the elections bill.
Other than, no, I've never any